Okay. So, welcome everyone. The first part of this seminar will be in English as a thank you note to our foreign guests.
Thank you for being here, because I couldn't understand it if it wasn't
Yes. And it is first and foremost a great honor to be here and have such a distinguished group of people sharing with us something that's very kind to our heart, which is the launch of the Global Center for Peace Studies at the University of São Paulo, together with its Conflict Resolution Center. As you all know, we're living in a time now where we're very much in need of peace and the resolution of conflicts. And to form this first panel, we have the honor to have with us Professor Martin Hunter, who is a barrister from Essex Court, London, and an honorary professor at King's College, London, and one of the greatest specialists in international arbitration in the world. And Julio Bueno, from a partner at Pinheiro Neto Advogados, doctor from Cambridge University, and originally alma mater, Largo São Francisco, University of São Paulo, too. So we started together. We were first-year students together a few decades ago, and it is really a great honor to have you with us today. And Dr. Frederico Straube, who is a leading figure in the world of international and national dispute resolution in Brazil, also a former member or a continuing member of our alumni group at the University of São Paulo Law School. So thank you for all our members of this panel. And we are very honored to have Professor Vahan Agopyan here, who is the Vice President at the University of São Paulo, who will share a few words with us.
Ladies and gentlemen, welcome to São Paulo. It's a great pleasure to have you with us. Thank you very much for coming to São Paulo to share your knowledge and your expertise in this subject. I would like to say that I'm very happy that we are doing several activities today. First of all, to start this Center of Study of Peace. This is a very important subject. We always discuss peace, discuss how to solve conflicts and so on, but now we're going to put the things into practice. Second is to establish this Conflict Resolution Center, which is a major step of, let's say, of the link of University of São Paulo and the community and society. I'm very pleased that this center will be established between University of São Paulo and the Union of Building Industry in the state of São Paulo. So let's say it's joint efforts of the academy and the industry together for one same purpose. And finally, my congratulations for all of my colleagues and the present people, that you are discussing something which is very important, up to date, as you mentioned. It's something that we are nowadays suffering, and we have to give an answer to the society, what we can do to improve our interactions, how we can improve our relationship commercially, industrial, and social relations, and how we can manage to make it more fruitful. I hope that this meeting will be very, very interesting. I'm sorry I have to leave, but I'm returning as soon as possible to join you and to go for this afternoon together. Thank you very much.
Thank you, Professor Vahan. So that we get started with this panel, I'd like to invite Dr. Julio Cesar Bueno for his first words. If you could tell our audience and our co-panel members today what are some of the issues that you will deal with in the realm of the challenges of establishing and maintaining ethics. Ethics is a very important discussion that we have when we have to talk about conflict resolution and the maintenance of peace.
Thank you very much. It's a great pleasure, great honor to be here. And I'm very happy that I will speak first because I believe the most important and difficult questions for Professor Straube, Professor Martin Hunter. Thank you, Gerson, and congratulations for Sinduscom and the University of São Paulo for this event. It's interesting, I found very interesting the idea of the topic, because for many years in Brazil, and I would say in Latin America as a whole, the tradition of dispute resolution was, of course, in judicial courts. And then, when the concept of arbitration came to Latin America, there was, I would say, a strong effort to educate, in some aspects, evangelize people about the good aspects of arbitration, and also the feasibility of arbitration, and that arbitration would not be something that would take apart the rights of people, and would also be something that would give stability and would give an answer to the needs of the society. Then, during the debate of the introduction of arbitration in Latin America, I would say we focus on the good aspects. When we are selling something, of course, we do that. And then initially was a perception that arbitration would be a panacea and would resolve all the matters, and also would not need to be worried about certain aspects of, I would say, that we normally have in relation to the judicial process. And I think that was important, it was necessary, and with the maturity of arbitration in Latin America, in Brazil especially, comes also a time where we have to discuss other aspects. And we have been doing this in the past years. We have been discussing the improvement of the regulations, the improvement of the work of the institutions, and the improvement of the participation of the parties and in the process. And I would say a great aspect is really the concept of ethics. And Brazil does not differentiate, and Professor Straube certainly will discuss this in a more profound way, the concept of national international arbitration. So we say everything is international, or as you want to perceive is national. There's no difference. If you have an arbitration here, we don't make that difference. So you just need to have your award if you internationally pass through the Superior Court of Justice, and then you can have the foreclosure here, and so on. This was a very important point in the initial of our arbitration process in 1996, because made possible for the Federal Supreme Court to accept the validity and to embrace arbitration, and then the Superior Court of Justice also to embrace arbitration in 2002 and so on. But the discussion about ethics is not new in international arbitration. Certainly since the 90s or even early, there are several aspects of ethics that have been discussed. There are important papers from Young Possum, Doc Bishop, and many others debating this concept. And also in the construction area, which is the area, infrastructure, the area that I work, other aspects that have been discussed in Australia and other countries as well. And the initial point when we talk about ethics in international arbitration is really how the representatives, they should be appearing before the arbitration. Because if it's international, we don't have one single bar regulation. If it's international, we don't have one single cultural concept. We may have an arbitrator from China, arbitrator from Mexico and from Brazil, and the lawyers can be from UK, and we can have the meltdown of these cultural aspects included in the process of arbitration. And then the great effort that was made, I think, by the institutions and also by the guidelines, and I mean the IBA guidelines, but also the efforts of ICC, LCIA, and many international arbitrations, and also internally in Brazil by all the national arbitrations, especially CCBC that was had the honor to have the president for Straube there guiding for many years, was to give to the parties and the representatives of the parties some guidelines where they should follow. So we may have now some difference, but when we approach arbitration in Latin America, sometimes, and I would say it's an expression that I believe I will try to translate to English, is we become more royal than the king. I don't know if that's the proper expression. And sometimes we have arbitrations in São Paulo that they are even more, they are even stricter, I don't know if this is proper word, than in New York or in UK. So the parts, they have a very strict approach to procedural guidelines. And that was, I would say, the initial phase to guide the parties and their representatives in relation to ethics. So we are learning how to do arbitration, international arbitration, by following codes and following. You have to do this. You have to follow this procedure, and this was important. But then another aspect comes to mind is the aspect of clean hands. That is very important in common law, that you have to present yourself to the court with clean hands. You have to respect the jurisdiction. You cannot act in contempt. And you can present your case in a matter that you have to gain the trust of the panel. So, basically, you shall not lie. Maybe there is a better way. Thou shall not lie. And then comes, I would say, some difference between common law and civil law. Because this is not that we like to lie. Of course not. But this concept is alien to the concept of civil process, that you don't lie, but you don't need certainly to appear so clear with clean hands before the other party and before someone that will be judging you. That's why we have difficulties to accept the full discovery concept. Why I should present all the documents that I have. Let's then find out that I have this special document here. And if they found out, okay. And those differences, I would say, in the near phase that we are now, they will really show the embrace of ethics in the new perspective for the Latin American countries in relation to international arbitration. So, the same way that Brazilians, when they go abroad, they behave in a better way than sometimes they behave here, because they are also praising the culture of a country that respects the line, respects. Also, this is a process, a cultural process that we are step by step embracing here. The final initial comment I would say, so this is an important point. We have to maybe to discuss this in a way that when we deal with arbitration, we deal in the concept of clean hands, in the concept of a transparency of someone that accepts this model as a model of dispute resolution. But then the final point, and I'll finish here because I want to listen to my professors here, is that we have now come to the point that we have to take a look on the arbitrator's position as well. The sanctity of arbitration also was transferred to the sanctity of the position of arbitrators. And in my experience, the disappointments that my clients always had with arbitration was when they found out that the arbitration was not so straightforward, so open to them. So the clean hands approach has to be also coming from the arbitrator. What do I mean by that? The arbitrator has to say that he's available, and he has to show his availability to take care of that case with full force. He cannot have 54 cases simultaneously, because arbitration is different from the judicial process. Secondly, he has to be able to say all the aspects of conflict of interest, even if he loses that case. But there is no gray line possible here. We have to say, I did that, that, and that. I worked for this party. I'm involved in this case. And what I feel, and maybe that's our tradition of a cordial society in Brazil, is that sometimes the parties, they don't want to confront the arbitrator about those aspects, either because they believe that this there will be a backlash against them later on, or because they feel that this is awkward and will not be comfortable for them to say. Then, but I think those two aspects, especially the last one, they will define how international and how will be our relation with the society. The arbitrators, they have to be completely clear in relation to their conflict of interest, and in a way that it's not a matter for them to decide the aspects that will be defining the uncomfortable aspects of the parties. The parts they have to know everything, so they will say, I'm comfortable or I'm not comfortable. I remember, I will give you two examples and finish. During one arbitration, I learned that one of the arbiters became partner in a law firm with another arbitrator, one of the arbitrators. This was not a problem for me, but was a real problem for my party. He was not comfortable with that. He said, I appointed 3 arbitrators. I want them to be independent, impartial, but I want them to have their free thinking. If they are partners, maybe this will be a problem. And as this was not disclosed during the process, and when you do not disclose something, you may open people to all interpretation, then there was this feeling of not being completely open. And the final example is a case where after we learned that the arbitrator, through his wife, had done a lot of work to the company that we were litigating. And again, of course, I know there is a distinction between but it was not that they were in completely different firms. They were really working together in some case, although he was arbitrator. He could have said that. And the parts, yes or no, they would accept. But then this feeling that things were not so clear, they're important. So I finish here with those 3 aspects. The importance of the institutions to really guide the parties in the cultural process, the clean hands approach in both ways, and the importance to embrace ethics and to demonstrate that in the day by day, if you are, especially if you are in a position to judge someone's right. Thank you very much.
Thank you. Thank you very much, Dr. Julio Bueno. we have an approach. No, you're good. We have an approach today that we're starting from specific and we go to more general. Normally you go the other way around, right? You start from general, you become more specific. So for those of you who are not too familiar with the world of international arbitration, don't worry, it will become more a discussion of peace and conflict resolution in a broader manner. Dr. Julio Bueno was talking about guidelines. Are there guidelines for decision-making in conflict resolution, in international arbitration specifically? And here we have a specialist on guidelines. There is a set of guidelines called the IBA guidelines. That's the International Bar Association. And this center specifically intends to abide by those guidelines very strictly. And they have a very simple way of defining some of those guidelines with a red light, a yellow light, and a green light. And we intend to abide by those very, very strictly. An example of those guidelines, if an arbitrator is an arbitrator for a party once, that's a green light. Twice is a yellow light, and then more than 3 times, you start establishing a relationship with that party, which is not something. Yes. So that's black, exactly. So I'll move forward to Professor Martin Hunter and let him tell us a little bit about that over the next 10 minutes.
Thanks. I don't know. I think I just need, because this is more of a discussion than a lecture series, if I understand correctly. Now, this question of witnesses and lying, which he refers to. Do you know, the medical profession has proved that witnesses cannot help themselves. They replay in their minds events that they're going to give evidence about, and they convince themselves their version of a story is completely true. And I mean, any of you people who are married will know that the truth is a little bit flexible in that sort of way, but they can't help lying, or most witnesses can't help lying. They can't avoid it because they know they're going to have to tell their story in due course to a panel of arbitrators or a court, and they replay the events in their mind again and again and again, and then it becomes the story they decide to tell is for them the truth, and so they're not, in a way, they're not lying because they're telling the truth as they see it. And that has been, now my chambermate, Toby Landau, who's done a lot of work on this topic, and although so far he hasn't published it, which I think is a great pity, but he's really got into this and has demonstrated, with the help of medics, that that witnesses, the story witnesses tell is the truth from their perspective, which is very complex. It means, indirectly, that most arbitrators, and I think most judges, think that the evidence of contemporary documents is much more compelling. When I say contemporary documents, you understand that I mean documents that came into existence at the time that the events giving rise to the dispute occurred. Anyway, that's just by the way. Stop me, by the way, if I go on too long. Stop me, because I have, unfortunately, I don't have, well, that is my text. I don't have a text. I have some notes, but I can't read them anyway. But I'll go back now to my theme, which was that when Gerson invited me to participate in this event, I said, sure. What would you like me to deal with, to cover? And he said, well, what about fact-finding by international tribunals? And I said, well, that would be a good topic because it isn't easy, and it's all done, of course, through, quote, evidence, unquote, whatever that means. And evidence can be anything. Is that, I can't read from here, but is that, yes. Oh yeah, I asked them to put up a small part of the IBA rules of evidence on the screens. There's one there, yeah, there's in several places. And I quote, document means a writing, communication, picture, drawing, program, or data of any kind, whether recorded or maintained on paper or by electronic, audio, visual, or any other means. Now that is the definition in the IBA rules of the term document. Now, can you imagine anything more, any definition wider than that? It means everything. Everything which has a permanent record of it is a document for the purposes of the IBA rules. I think that's a very telling and meaningful aspect of looking at evidence. And by using the term evidence, of course, evidence, I suppose, is a legal term, or term invented by lawyers for lawyers. But it can be anything, effectively. We often see newspaper items referred to during arbitrations and the like. And it's an interesting topic, partly because it's more a question of culture than of legal training. Identifying what is evidence, what the value of evidence is, because at the end of the day, that's what you have arbitrators or decision makers for, is to review the, quote, evidence, unquote, and then determine, on the basis of their personal reviews, the value of the evidence in terms of deciding the facts that are pertinent to the dispute. We tend to make a distinction between common law and civil law, which is an interesting distinction, and it is relevant. I don't complain about it when people make that distinction. But it's too broad a view of it. And you only got to look at the difference between French procedural law and the neighboring country, German procedural law, to know that the two systems are completely different. And it's interesting that the Middle East, for example, almost the whole Arab world, their procedural law is based on French law, French procedural law. Whereas in Russia, Japan, China, they're based mainly on German law. It's for historical reasons. And you get two completely different forms of analysis of quote, evidence, unquote. Now, we can't do anything about it, and it doesn't really matter, because so long as you have tribunals composed of arbitrators or decision makers who can bring their own personal perspectives, the way they look at evidence, then that's fine. But of course it does mean it puts a specific spin on the way people choose their arbitrators. Now, for whichever system, common law or civil law, the procedure to be followed in any particular arbitration is adopted, it's useful to go back to fundamentals and to look at what institutions do, institutional arbitration systems do, when it comes to reviewing evidence. I tried to do some research on some of the institutions that I've not really had much to do with over the years, including the International Court of Justice in The Hague, and the International Criminal Court, which is much more recently established, which is also in the Netherlands, and then, of course, the one that I do know about, which is the International Bar Association's 3 editions of its rules on the presentation of evidence, which is the document that we've got up on the screen. I was actually a member of the committee of the IBA that did prepared the first edition of the IBA Rules of Evidence. And I'm sorry to say that it was not a success at all. This is because it was dominated by common lawyers, the committee was. And we didn't understand. I mean, this is now back in, I can't remember, 79, I think. But it didn't work. So the civil lawyers didn't buy it. The next edition, the second edition, was much better, and the third edition, if you go back, it doesn't matter actually. Just let me make the comment that this version of the IBA rules does recite the names of all the people who participated in it. And the third edition, which is 2010, and it has people like John Beechey, who one of the top guys well, he was I think they call him the president of the ICC's Court of International Arbitration. And he did, amongst other people there, he did a terrific job. I couldn't find much inside the International Criminal Court's rules. That seems to be very subjective to the particular judges hearing a particular case. I don't know how many of you have had any experience with the International Criminal. It's tempting to call it the ICC because it's got the same initials as the International Chamber of Commerce. But, I mean, in that context, International Criminal Court. But I think it's a new institution, and relatively new. But I think it's going pretty well, actually. I don't know if anyone else has, anyone here. Marika, do you have any experience at the International Criminal Court? I don't either. how am I getting on with my 15 minutes? I must be getting close. Well, why don't... Yeah, I mean, we can... I feel that I've taken up enough of your time. If I get an opportunity to comment later, that will be nice. But why don't I hand over now back to Gerson, and he can hand over to Frederico.
Thank you very much, Professor Martin Hunter. And now we'll hand over, maybe you can use that microphone, to Dr. Frederico Straube, who will give us an overview of what's happening in the Latin American region.
Good afternoon, my dear colleagues, ladies and gentlemen, my dear colleagues of Painel. It was a pleasure to hear Julio Bueno, a person that I know since many time, and also it's always important to listen Martin Hunter. We are always learning with him. Every time I have the opportunity to hear or to read Martin Hunter, we are becoming a little bit greater in arbitration. So I'll speak about, I prepared some elements about the institution of the development of institutional arbitration in Latin America. But I need my spectacles. I forgot that. Always I'm thinking that I'm still young. The role of arbitral institution in the development of arbitration in subject that has been increasingly discussed in international forums. In the 2014 ICA Congress in Miami, the relationship of such entities with legitimacy was the topic of an entire panel. And one of the main concerns regarding the matter is the growth of local institutions in opposition to the predominance of traditional international centers of arbitration. Such discussion is especially important in Latin America, where the development of arbitration is related to the emergence of local arbitral institutions. In fact, in the continent, such entities encourage best practice and provide the national market with the necessary certainty for the strengthening of a commercial exchange. Interestingly, the evolution of ADRs in such era also promoted the growth of several local institutions. Okay. Thank you. In this context, the Institute for Transnational Arbitration conduct a survey regarding the situation of a local arbitral institution in Latin America. The results of the survey pointed out that most of these entities were created after 1990, when local jurisdiction has already set a legal framework for arbitration. Theoretically, relevant institutions provide better conditions for parties in council through the reduction of costs and the more adequacies to the national legal order or traditions. Moreover, it's often pointed as a reply to the criticism directed toward arbitration's legitimacy, based on the fact that most arbitrators and councils belong to developed countries. Local entities from developing countries have among their roles national arbitrators who normally do not come from Europe or the United States. In this scenario, local arbitral entities would serve as an antidote to protect the legitimacy of arbitration with respect to regional particularities. However, there are two facts that undermine such argument. First, the strength of a national or traditional international arbitral institution continues in Latin America. At the end of 2002, there were more than 1,135 cases in the International Arbitration Court of the ICC, 175 from Latin America. In 2012, there were only 168 cases submitted to the 6 most renowned arbitral Brazilian institutions, while the ICC received 82 cases from Brazil alone. This illustrates the appeal that traditional arbitral institution keeps in Latin America, despite the development of new centers that compete with them. Second, most Latin American councils and arbitrators are used to carrying out their cases in European and North American traditional institutions, meaning that they tend to keep the same practice in their proceedings submitted to local entities. Moreover, they attend courses offered by such entities and obtain LLMs or PhDs in universities in countries that have an arbitral tradition. Thus, the arbitral culture of such countries are incorporated by Latin American professionals who reproduce it instead of creating a regional standard. Therefore, we can say nowadays that it's possible to state that a local institution can secure the legitimacy of arbitration, and their perspective of increasing the qualification is interesting. The survey carried out by the ITA mentioned above concludes that the number of cases involving at least one foreign party has significantly grown in Latin American institutions. The same thing happened in terms of arbitration concerning the public administration and in case with the multiple parties. Such outcomes reflect the evolution of those entities and their emergence as international players. As I have been president of the most traditional and renowned Brazilian arbitral institution, CANCE-CBC, I can certify that the development of the arbitration is related to the role taken by arbitral institutions in Brazil. Certainly, the enactment of our Arbitration Act in 1996, followed by the recognition of the accordance to the Brazilian constitutional order by the Supreme Court, was essential for the consolidation of arbitration in our juridical reality. The fact that before 1996, only 2 arbitral procedures were submitted to the Arbitration and Mediation Center of the Brazil-Canada Chamber of Commerce demonstrate the importance of a legal framework for the development of the RDR in Latin America. However, after the creation of a legal framework, the effort directed to consolidation of arbitration were made mostly by arbitral institutions that joined force with the academy and non-profit organizations with the purpose of fostering knowledge related to ADRs, such as the Brazilian Arbitration Committee. Thus, the number of arbitrations submitted to Brazilian institutions has been increasing in incredible proportion. Considering the data of CANCE-CBC, which I was quite aware for the reason that I just mentioned before, before 2003, there was an average of 5 new procedures in CANCE-CBC each year. In 2004, 11 cases were initiated, and in 2006, the number raised significantly to 21 proceedings. Last year, however, alone, it received more than 100 requests for arbitration. Moreover, before 2010, more than 90% of the cases under CBC rules involved only Brazilian parties, in contrast from 2011, on around 17% of arbitration proceedings have had at least one foreign party. Important foreign companies include arbitration clause under Brazilian Arbitration Center rules in their agreement. It's important to note that our data is in accordance with survey recently carried out in other Latin American institutions, demonstrating the development of arbitration in the continent. In other words, those numbers are the ultimate evidence that foreign parties have sufficient confidence in such institution to sign agreements containing arbitral clauses under their rules. Despite this optimistic number, it's important to bear in mind that there is still space for growth. A relevant share of the Latin American arbitration market still belongs to traditional institutions. Also, there are specific areas in which arbitration is embryonic, such as arbitration with the public administration or in consumer relations. As such, it's possible to conclude that local arbitration institutions from Latin America have grown significantly, but many obstacles must be faced for them to achieve their full potential. Thank you very much.
Thank you, Dr. Frederico Straube. For us, it's also a great honor to announce that we have two of the most renowned and ethical people in the field of international arbitration become a part of our Center for Conflict Resolution. Dr. Frederico Straube will be the president of our Chamber of International of our National and International Arbitration, and we'll have Professor Martin Hunter as being our Vice President for Europe. The next panel will have to announce Marika Paulson, who will be our Vice President for the United States and North America. So that we can catch up with our sequence here. I know that in our next panel we'll have Enrique Iglesias, who needs to leave relatively soon. So we can save questions for a little later, and we'll just change to the next panel if everyone agrees with that. Is that fine? Okay.